Hi drivers, my name is Paul Taylor. I'm one of the attorneys here with Truckers Justice Center. We represent truck drivers in disputes with trucking companies, or at least that's the vast majority of the types of cases we do. So this video is going to talk briefly about what is your lease dispute case worth if you have one. So there's a lot of factors that go into determining what a case is worth from a settlement perspective. So, what a case is worth from a settlement perspective is much like negotiating a sale of a truck or a car or a house. It's worth what somebody's willing to pay to resolve it. So factors that go into evaluating a case when we take it is, one is, do we have an ability to get paid? If we're suing some tow truck operator out of Elk Grove Village, Illinois, who doesn't speak English, and is going to close up and then open under his uncle's name, that case is worth little. It's probably something we wouldn't take. But let's talk about a lease case, say, for example, where somebody's skimming on your percentage. So there's DOT lease regulations which govern the leases between owner-operators or truck owners or lessors and trucking companies. The lease refers to trucking companies as authorized carriers. That means they're subject to the leasing rules. You're hauling interstate in interstate commerce. So the lease rules provide that you have to be paid what the lease says you're going to be paid. If you're paid on percentage, you have to be given access to proof of what they're charging. And the lease rules say if you're going to be charged back anything from settlements like fuel, advances, pallet exchange, claims, it's got to say so in the lease. So on your very best day in any case involving a lease dispute, and I'm not talking about those crazy lease purchases where you've made a bad business decision to purchase a truck and it's unfair, because the law doesn't say a carrier has to treat you fairly, they have to treat you legally. But if you're a bona fide owner-operator on your best day and you're getting skimmed from, you get what you are out. So if the lease says you're entitled to 80% of gross revenue billed and the lease is silent, say for example, how gross revenue billed is computed, we know what gross revenue is. It's that bottom line on that invoice to the broker, to the shipper. So if you get 80%, you're entitled to 80%. You are not entitled to pain and suffering. Doesn't happen in contract cases. Lease dispute cases, while subject to the DOT's leasing regulations, are at their base a contract dispute. So there is no pain and suffering. There is no claim for punitive damages. If the carrier has been deducting items like bobtail insurance and been marking it up, and your lease says they're not entitled to it doesn't say anything about a service fee. It just says if you buy bobtail insurance through this company, it will charge you back. You will be liable at cost. Then you're entitled to the markup. Now, normally on bobtail insurance, that's going to be pretty skinny. If it says you're responsible for claims for loss and damage to goods, in transit, with no limitation, nothing about a deductible, nothing about cargo insurance, they're entitled to charge you back the cost of that claim if it's a valid claim. Now, if the carrier chooses to simply pass on that cost to you and just pay the claim because they want a happy camper shipper or broker, that's a different issue. But you are never entitled to get more than what the lease says you are entitled to get. And by the same token, part of your damages could be what the carrier is charging you back in the way of costs, expenses, claims. They can only charge you back what the lease says they can charge you back for, and it has to be pretty specific. The other element under the truth and leasing law, truth and leasing regulations, and the law that says we can enforce those for you, or another attorney can, or you can representing yourself, is that you're entitled to a recovery of attorney's fees. So what is a case worth? On its best day, a truth and leasing claim is worth what you are out. Not punitive damages, not mental pain, but on its very best day. Other things that factor in is what is going to be the cost of litigation, where's it at, and the ability to pay. So ability to pay is the second most important factor in assessing what a case is worth. So it's generally not worth it to chase deadbeats. It may be worth it to change chase slow payers. Thanks for watching. Be safe out there.